Page 49, Chapter 5, Guardianship and People with IDDD, A Story from the Nation's Capital. Introduction. Who is filing guardianship petitions over people with IDDD? Are suspicions of a school-to-guardianship pipeline for people with IDDD borne out in actual guardianship data? Do people with IDDD in guardianship ever seek to have their rights restored? Data-supported answers to these and other more granular questions impacting people with IDDD are not available for the United States as a whole. Therefore, this project turned to the local level by undertaking an in-depth examination and analysis of the experience of people with IDDD who live in Washington, D.C. The District of Columbia is a prime place for such an examination. The treatment of decision-making rights of D.C. citizens with IDDD has recently been highlighted on the national stage. During recent U.S. Supreme Court Justice confirmation hearings, repeated references were made to a 2007 U.S. Circuit Court for the District of Columbia decision, Doe ex rel. Tarlow. This court decision was condemned by several disability rights organizations for not respecting the wishes of all of D.C. citizens with IDDD with respect to their own medical care. In addition, this case highlights the way in which the D.C. government used to consent to elective surgeries, including abortions, for certain citizens with IDDD without attempting to ascertain their wishes. Since that time, D.C. laws and governmental practice impacting the decision-making rights of people with IDDD improved in significant ways. However, that concerning history remains in the minds of many local advocates and D.C. residents with IDDD. As one D.C. advocate with IDDD said with respect to the Doe decision, "Nothing about us without us." In addition, from a data gathering standpoint, identifying and tabulating guardianship cases that specifically involve people with IDDD rather than other disabilities is easier in D.C. than in other larger jurisdictions, because D.C. has only one court branch with authority over guardianship matters. D.C. also has a computerized system with court filings and other information publicly available for review. In addition, the D.C. Department on Disability Services is legislatively required to gather information on decision-making supports used by the people with intellectual disabilities that it serves. D.C. also has recently undergone promising legislative and policy reform designed both to bolster due process rights for people facing or in guardianship and to promote alternatives to guardianship for adults with disabilities in special education and beyond. This presented an opportunity to find out whether these reforms have yet resulted in meaningful outcomes for residents with IDDD in the nation's capital, and if so, whether DC's local approach can inform federal-level policy recommendations and serve as a model to other states. Page 50. The excerpt reads, "The D.C. law also states that incapacity must not be inferred from the fact that a person has an intellectual disability." Page 50. Why NCD picked D.C. for an in-depth examination of guardianship. D.C. has only one court branch with authority over guardianship matters, making it easier to identify and tabulate cases that specifically involve people with IDDD. D.C. has a computerized system with court filings and other information publicly available for review. The D.C. Department on Disability Services is required to gather information on decision-making supports used by the people with ID that it serves. D.C. recently underwent promising reform designed to bolster due process rights for people facing or in guardianship and to promote alternatives to guardianship. Key D.C. legislative and policy reform. Legislative reforms for adult guardianship proceedings. In its guardianship law, D.C. has several long-standing safeguards and due process protections. For example, people facing or in guardianship have an established right to counsel, both in the initial and post-appointment court proceedings, such as restoration cases. Even if a person is found by the court to be incapacitated, a guardian may not be appointed unless it is necessary as a means for providing continuing care and supervision of the person, which allows for court consideration of less restrictive alternatives to guardianship. The law also states that incapacity must not be inferred from the fact that a person has an intellectual disability. The law further provides for scope-limited and time-limited guardianships and requires the court to exercise its authority so as to encourage the development of maximum self-reliance and independence of the incapacitated person. When the court appoints a guardian, the law further provides for scope-limited and time-limited guardianships and requires the court to exercise its authority so as to encourage the development of maximum self-reliance and independence of the incapacitated person. When the court appoints a guardian, it must be the type of guardianship that is least restrictive to the incapacitated individual in duration and scope, taking into account the person's current mental and adaptive limitations, the person's ability to improve his or her condition, or other conditions warranting the appointment. General and limited guardians are generally required to make decisions for the person using the substituted judgment standard and to include the person in the decision-making process to the maximum extent of the person's ability, and encourage the person to act on his or her own behalf whenever he or she is able to do so, and to develop or regain capacity to make decisions in those areas in which he or she is in need of decision-making assistance to the maximum extent possible. However, local disability rights advocates have raised concerns regarding how the due process protections within the DC guardianship law have been translated in practice for residents with disabilities. Related advocacy led to the DC Guardianship Amendment Act of 2014, which went into effect in March 2015. In addition to other reforms, it bolstered the due process rights of people in guardianship proceedings in two main ways. Page 51. The excerpt says, DC Wings developed a new complaint process by which anyone can raise concerns about guardians and conservators that are appointed with the court. Page 51. First, the Act requires attorneys who represent people in or facing guardianship to zealously advocate for their clients' expressed wishes. If the person is completely incapable of expressing such wishes concerning guardianship, then the attorney must advocate for a result that is least restrictive of the person's liberty and consistent with the person's interest as determined by a guardian ad litem. This amendment was designed to counteract a 2010 DC Court of Appeals decision in Re Martel, which held that the original guardianship statute's wording allowed an attorney to meet his or her obligation by advocating for what a guardian ad litem determined was in the person's legitimate interests, even if the client disagreed. Second, the Act mandated periodic court review of guardianships established after January 1, 2015, to determine whether the guardianship continued to be the least restrictive option or whether it should instead be modified or terminated. The reviews occur every 3 years after an investigation and report by a case reviewer who is a social worker assigned through DC's Guardianship Assistance Program. That investigation must include an updated medical or psychological information about the current capacity of the person in guardianship, as well as the person's expressed preferences about the scope and duration of the guardianship and their opinion of the guardian. The law also requires a court hearing to be held if the person in guardianship requests one, or if the case reviewer recommends the guardianship be modified or terminated, or the guardian be removed. DC Wing's complaint process and trainings on alternatives to guardianship. In 2015 and 2016, as a result of the efforts of the DC Working Interdisciplinary Network of Guardianship, Stakeholders Wings initiative, led by the DC courts, other steps were taken to improve the guardianship system in DC. In addition to its efforts to improve public education on guardianship through the court website, brochures, and videos, DC Wings developed a new complaint process by which anyone can raise concerns about guardians and conservators that are appointed with the court. When such a complaint is submitted, the court may take several actions, including appointing a social worker to investigate the case, referring the case for mediation, holding a hearing, or referring the complaint to a law enforcement agency, among others. In the fall of 2015, DC Wings also provided training to attorneys and other legal stakeholders to reinforce that guardianship was the option of last resort, ensure alternatives to guardianship were understood, and improve understanding of capacity assessments. The trainings included discussion of the full range of decision-making options then available in DC, including SDM, advanced directives, powers of attorney, representative payees, and substitute healthcare decision-makers under DC Code 21-2210. 21-2210, medical decision-makers, among others. Page 52. The excerpt at the center of the page says, DCPS began an initiative to introduce SDM beginning in pre-kindergarten to teach students how to build networks of support early to ensure that they are familiar with the process and utilize it in day-to-day activities. Page 52. DC Special Education Reforms to Promote Alternatives to Guardianship. In DC, while general education students typically graduate from high school by the age of 18, students in special education have the right to remain in school until the end of the semester in which they turn 22 years old. 112 under DC law, when students turn 18, their parents' rights under the Individuals with Disabilities Education Act, IDEA, automatically transfer to the student unless a court has found that the adult student is incompetent. This process is referred to as the transfer of rights, and it frequently triggers discussions about guardianship. As one DC disability rights advocate said, in my experience working with transition-age students with IDDD, I have seen a bias by schools and support teams to use the transfer of rights process to push parents towards going to court to get guardianship over their adult child, rather than first exploring less restrictive decision-making options, like powers of attorney and supported decision-making. Because of this institutional bias within the disability service delivery system, we have had to expend much effort and energy on counseling and supporting families to understand that guardianship is not the only option available. In 2012, a coalition of DC disability rights advocates issued a call of action against the transfer of rights guidelines of the DC Public Schools, DCPS. These March 2010 guidelines failed to inform parents and students about less restrictive alternatives to guardianship, such as educational powers of attorney, or SDM, instead presenting the issue as a dichotomous choice between the students exercising their IDEA rights completely by themselves or their parents seeking guardianship if they wanted to remain involved in educational planning. In addition, DCPS was taking the position at some administrative hearings that students in special education could not delegate their IDEA rights to their parents or caregivers through the use of educational powers of attorney, despite the fact that district law expressly allowed parents to delegate rights and responsibilities for all school-related matters when their child was a minor. As a result of this community advocacy effort, in August 2013, DCPS amended its transfer of rights guidelines to expressly recognize SDM and also developed a standardized form by which such arrangements by adult students in special education can be documented. In addition, DCPS began an initiative to introduce SDM beginning in pre-kindergarten to teach students how to build networks of support early to ensure that they are familiar with the process and utilize it in day-to-day activities. Alternatives to guardianship for adult special education students were also included in comprehensive special education reform legislation that was passed by the DC legislature in late 2014. The DC Special Education Student Rights Act of 2014, which went into effect in March 2015, affirmed that students who have reached the age of 18 have the right to receive support from another adult to aid them in their decision-making, page 53. In so doing, it extended DCPS formal recognition of SDM to all schools in DC, including public charter schools. The Act also affirmed the right of adult students in special education to execute educational powers of attorney and require the D.C. Office of the State Superintendent of Education, OSSE, to create a new alternative to guardianship for students who are unable to make educational decisions, even with support, or to knowingly and voluntarily execute a power of attorney. This new alternative became known as an educational representative. The Act also required parents be notified of the transfer of rights as well as all these alternatives to guardianship, no less than 1 year before the student turned 18 years old. In July 2016, OSSE implemented regulations for this act and issued a model SDM form that can be used by all schools, whether they are connected to DCPS or not. Among other things, the regulations describe how the educational representative process works. An educational representative is someone, usually a parent, appointed by OSSE to make educational decisions for an adult student who is unable to make those decisions. Even with support, and it does not require court involvement, a parent or other interested adult may submit to OSSE the request for appointment. Along with 2 signed professional certifications of the student's incapacity to make educational decisions, if all its rules are met, OSSE will then appoint the educational representative and provide notice of the appointment to the parents, students, and school. The notice describes the steps that the student may take to challenge the appointment, and the school is required to give a copy of the notice and explain it to the student. If the student objects, then the certifications are invalidated and all educational rights transfer back to the student. However, respondents that were interviewed raised questions about whether information about the full continuum of decision-making support are really making its way from schools to students and families. For example, one parent reported that coordinators at public charter schools and DCPS do not have a full understanding of the impact of guardianship or the availability of alternatives such as powers of attorney and SDM. Maybe a handful out of the 200 or so that are out there do. We really do need to get them much more comfortable in explaining the difference, or at least pointing parents in the right direction. When students are 15, 16, in their IEP meetings, I think they really need to ramp up the trainings. I know it's a very low priority level, unfortunately, but I think that they are the ones who are going to open the door of understanding to the parents. Reforms recognizing supported decision-making across the lifespan. On September 21, 2015, the chairman of the D.C. Council, at the request of the D.C. mayor, introduced Bill 21-0385, the Citizens with Intellectual Disabilities Civil Rights Restoration Act of 2015. This bill, among other things, proposed to formally recognize SDM across the lifespan through the codification of a SDM agreement form and was drafted under the leadership of the D.C. Department on Disability Services. Although it did not pass the D.C. Council that legislative session, the introduction of Bill 21-0385 started a broader dialogue about SDM that made lawmakers, governmental agencies, and the public more familiar with the concept of how it could be operationalized in D.C. Page 54. The excerpt at the middle says, this law change was preceded in October 26 by the first D.C. case to terminate a guardianship in favor of SDM. Page 54. The legislation was reintroduced on March 3, 2017, in a modified form as Bill 22-0154, now known as the Disability Services Reform Amendment Act of 2018. It passed the D.C. Council on February 28, 2018, and became law, effective May 5, 2018, making D.C. the 4th jurisdiction in the United States to codify SDM agreements. This law change was preceded in October 2016 by the first D.C. case to terminate a guardianship in favor of SDM. The case involved Ryan King, a person with IDDD whose victory was showcased in the 2018 NCD report and shone a spotlight on SDM locally and nationally. In addition, DC's 2016 Olmstead Plan, which is a way for states to document their plans to provide services to people with disabilities in the inclusive and integrated settings pursuant to the Americans with Disabilities Act, ADA, recognize that guardianship is often seen as the only option for parents of children with disabilities rather than self-determination and supported decision-making. To combat this, it included governmental action steps that required the development and implementation of long-term care competency criteria, standards, policies, and protocols on the consistent use of person-centered approaches to service and planning, including using principles of supported decision-making. By the numbers, guardianship and DC residents with IDDD data collection initiative at the DC probate branch. Using publicly available information from the DC probate branch, this project gathered key data points for the over 1,500 new guardianship cases opened over the course of 2015 to 2017, and identified the subset of cases where the alleged disability was IDDD. There are several trends that are worth highlighting. Page 55. Number of guardianship petitions. There's a chart here. Overall guardianship petitions in blue here. People with other disabilities in red. People with IDDD in yellow-green here. And then there's another chart here, percentage of new IDDD guardianship cases. Percentage of cases. They were on a decline from 2015 to 2016, and then they leveled out between 2016 and 2017. Page 55, the center excerpt says, the number of new guardianship petitions for people with IDDD, as well as their percentage compared to overall guardianship petitions filed, has generally decreased. The timing of the decrease coincides with the public dialogue surrounding the SDM bill, as well as the DC Wings trainings on alternatives to guardianship. Page 55. The number of new guardianship petitions for people with IDDD, as well as their percentage compared to overall guardianship petitions filed, has generally decreased over the course of the 3-year period. While there are many reasons why this is the case, the timing of the decrease coincides with the public dialogue surrounding the SDM bill that was first introduced in the DC legislature in 2015, as well as the DC Wings trainings on alternatives to guardianship. Most of the petitions were filed by family members. Others were submitted by government agencies, including Adult Protective Services, APS, the Department on Disability Services, and Child and Family Services. In a handful of cases, the person's own attorney or guardian ad litem from another matter, such as an eviction proceeding, filed the petition. The overall percentage of family guardianship petition filings increased over the 3-year period, which speaks to a need for targeted outreach to that population to ensure they are fully aware of less restrictive options. Page 56. Guardianship petitioners for IDDD cases. And there's a chart here for 2015. In blue is the family members, 50%. In red is the government at 42%. In yellow-green is the hospitals at 4%, and other in purple at 4%. In 2016, family members in blue, 67%, government in red at 18%, hospitals in yellow-green at 6%, and other at 8% in purple. In 2017, family members in blue at 61%, government in red at 31%, hospitals in yellow-green at 6%, and other in purple at 2%. The center excerpt reads, "The majority of IDDD guardianship petitions are for transition age adults, indicating that there is indeed some form of pipeline to guardianship for that population in DC." Page 56. "The majority of IDDD guardianship petitions are for transition age adults, indicating that there is indeed some form of pipeline to guardianship for that population in DC. While the number of cases for that age group has dropped since 2015, the percentage of the overall number of guardianship petitions involving people with IDDD has steadily increased. This is a troubling finding, as it suggests that the special education reforms to promote alternatives to guardianship may not yet be having an impact on the ground for the youth with IDDD." Page 57, another graph chart. Number of IDDD guardianship cases by age. In blue is 22 or younger. In red is 23 to 54. In yellow-green is 55 to 64. And in purple is 65 or older. And oops, I missed the one up top here. 2015 in blue, age 22 or younger. They were on the decline from 2015 to 2016, and on the increase between 2016 and 2017. That was 22 or younger. The 23 to 54-year-olds on the decline from 2015 to 2016, and on the incline from 2016 to 2017. In yellow is 55 to 64-year-olds. In purple is the 65 or older, which seem to be on the decline. Page 57. These data-driven concerns regarding ineffective implementation of promising special education agency policy and procedures are consistent with what the project learned from interviews with personnel at DCPS and OSSE. Currently, these agencies reportedly do not comprehensively track the use of alternatives to guardianship, such as SDM, educational powers of attorney, or educational representatives by adult students in special education. Although several of their trainings incorporate the concept of SDM, there reportedly have been no standalone trainings on that topic presented by these agencies, other than those periodically offered by local disability rights organizations. Page 58, another chart. Percentage of guardianship petitions in IDDD cases granted in whole or in part. In 2015, 93%. In 2016, 88%. In 2017, 90%. Percentage of guardianship petitions in IDDD cases granted in whole or in part. Page 58. Most of the people with IDDD who faced guardianship petitions were placed under guardianship by the court. The percentage did decrease somewhat from 2015 to 2016, which may be attributed in part to the court education efforts to attorneys and legal professionals on the availability of alternatives to guardianship. However, the percentage increased slightly in 2017, which underlines the need for continued training efforts by the court. When the petitions were granted, most of the individuals with IDDD were placed under permanent general guardianship, the most restrictive form. This data raises questions about whether courts are using guardianship as the last resort and whether they are consistently appointing the type of guardianship that is least restrictive in duration and scope to meet the person's needs. It may also indicate persistence in stereotypes about people with IDDD and their ability to be independent with supports, which could lead courts to weigh heavily toward full guardianship instead of alternatives. Page 59, another chart. Type of guardianship granted in IDDD cases. In 2015, in blue, permanent general guardianship, 87%. In red, limited permanent guardianship, 13%. In green, temporary guardianship, 0%. In 2016, in blue, permanent guardianship, general guardianship, 84%. In red, permanent limited guardianship, 7%. In yellow-green, temporary guardianship, 7%. In the year 2017, permanent general guardianship, 90% in blue, permanent limited guardianship in 7% in red, and temporary guardianship in yellow-green percentage, 2%. The center excerpt reads, while a periodic review of the continued necessity of guardianship is a promising DC reform, more time and analysis are needed to determine whether it will result in any restoration of rights. Page 59. The review also indicated that the people with IDDD in the data set did not seek to have their guardianships reviewed, either through a petition post-appointment for restoration of rights or through the new court guardianship conservatorship complaint process. There was not a single complaint filed in these cases. There were only 3 petitions post-appointment requesting restoration of rights, and none of them were filed by the person under guardianship. However, all 3 were successful and the individual's rights were restored. More education on these due process options for people with IDDD and their support networks is likely needed, particularly with respect to the complaint process, which has only been in existence for a few years. These considerations should also be given to ensure that tools are sufficiently accessible to and navigable by people with IDDD. Pursuant to the DC Guardianship Amendment Act, the first year of court triennial case reviews began in 2018. For this project's dataset, 21 such reviews occurred for people with IDDD through the Guardianship Assistance Program. Only 2 of the individuals involved were appointed an attorney to help them navigate the process, and none of the reviews resulted in restoration of rights. While a periodic review of the continued necessity of guardianship is a promising DC reform, more time and analysis are needed to determine whether it will have a concrete impact on people with IDDD under guardianship and whether it will result in any restoration of rights for them. Page 60. Another chart and graph. Type of decision-making support used by people with intellectual disabilities served by DC DDS percentages. In blue, independent decisions. Here and here and here and here. In green, durable power of attorney. I don't see, oh wait, there's one in 2018 and one in 2015, maybe 2016. Limited medical guardian or DC equivalent in light blue. And other in dark blue, presumed capacity under review. In red, supported decision making, pretty steady. In purple, 21-2210 medical decision maker in purple, very high for medical. And in yellow, general, guardian, or DC equivalent. Overall annual average percentages for the type of decision-making support used by people with intellectual disability served by DC DDS FY fiscal year 2013 to 2018. In blue, independent decisions at 14%, this one here. Durable power of attorney, 0.3%, not even on the chart. In light blue, limited medical guardian or DC equivalent, 15%. In dark blue, other presumed capacity under review, 13.3%. In red, supported decision-making, 3.8%. In purple, 21-2210 medical decision maker, 37.5%. In yellow, general guardian or DC equivalent, 15.8%. Data, page 560. Data from the DC Department on Disability Services on Guardianship and Alternatives. Under DC Law 17-249, the Healthcare Decisions for Persons with Developmental Disabilities Amendment Act of 2008, the Department on Disability Services, DDS, is required to submit to the Council of the District of Columbia, DC Council, an annual report and plan assessing the current and potential healthcare decision-making needs for all people served by DDS, which includes DC residents with intellectual disabilities. Page 61. The center excerpt reads, the most common form of decision-making support used by people with intellectual disabilities served by DDS is a 21-2210 medical decision maker, MDM. Page 61. This report includes data on the type of decision-making support used, including SDM, Durable Power of Attorney, 21-2210 medical decision maker, limited medical guardian, and general guardian. DDS has described the data as a snapshot, an approximation, because the numbers fluctuate from day to day as individual needs continue to change. However, the data tells an interesting story about the type of decision-making support that is being legally recognized as used by this population. While the number of people with intellectual disabilities identified as using SDM has increased over the past 5 years from 75 to 111, it has consistently remained the second least used decision-making support with the DDS intellectual disability system. With the May 2018 statutory recognition of SDM across the lifespan, this statistic may change in the future. As the data shows, the most common form of decision-making support used by people with intellectual disabilities served by DDS is a 21-2210 medical decision maker, MDM. In DC, when a person does not have a durable power of attorney for healthcare and has been certified to lack the mental capacity to make healthcare decisions by both a qualified medical doctor and a psychiatrist or psychologist, the law turns to a prioritized list of individuals to make those decisions for the person under DC Code 21-2210 of the DC Healthcare Decisions Act. For the purpose of DDS statistics, these 22-2210 MDMs are generally family members or friends who have not been appointed as the legal guardian by the court. The advantage of this law is that it allows the person to receive the health care he or she needs without having to go to court and risk having all his or her other non-medical related decision-making rights taken away in a guardianship proceeding. The downside is that the law requires non-judicial certifications of the person's incapacity to make healthcare decisions and does not provide a clear way for the person to challenge the 21-2210 MDM designation. In its most recent report, DDS states those listed as having a 21-2210 SDM may make many of their own decisions with or without support and may simply rely on the designated 22-2210 SDM in certain situations. According to this data, the least common form of decision-making support used by people with intellectual disabilities served by DDS is durable powers of attorney, with consistently less than 1% of the people served having one that DDS knows about. Durable powers of attorney, unlike 21-2210 MDMs, are a way a person can voluntarily designate someone to act for them in the event they are unable to make decisions themselves, and thus are a less restrictive option. The high percentage of people who are identified as having 21-2210s MDMs, who in DDS system are usually family members, as compared to the extremely low number with identified powers of attorney, raises concerns that DDS may be over-relying on a more restrictive tool than necessary to support the people it serves. Some of these individuals may be able to voluntarily execute a power of attorney instead, but have not been offered a meaningful opportunity to do so. Page 62. the chart says percentage of general versus limited guardianships for people with intellectual disabilities served by DDS. In blue, limited medical guardian or DC equivalent, it's on the decline. In red, general guardian or DC equivalent on the increase over the years. From year 2013 to 2018. Page 62 excerpt reads, while DC has been a national leader in reforming guardianship and promoting less restrictive alternatives, data demonstrates that there is still a need for further initiatives designed to implement these changes. Page 62. Unlike the DC probate court data review for people with IDDD, DDS data indicates that where there is guardianship, it is roughly as likely to be limited as it is to be general. This may be a result of DDS' stated commitment to the use of lesser restrictive types of decision-making supports whenever possible. It is interesting to note that over time, general guardianship for people served by DDS is becoming more common. Lessons learned from the DC experience. As indicated throughout this report, reliable national data on guardianship is scarce, let alone data specific to particular populations, such as individuals with IDDD. This deep dive analysis of guardianship's impact on people with IDDD within the District of Columbia provides rare data about what the number and types of guardianships are, whether guardianships disproportionately involves young adults, whether people with IDDD are using tools to restore their rights, and whether recent legislative and policy reforms have yet had a significant impact. Page 63. While DC has been a national leader in reforming guardianship and promoting less restrictive alternatives, the previous data demonstrates that there is still a need for further initiatives designed to implement these changes in a way that will significantly advance the decision-making rights of people with IDDD. For example, data shows evidence of a continued pipeline to guardianship for young adults with IDDD, despite the special education reforms designed to promote recognition of alternatives for that population. Lessons for other states. Lessons other states can learn from the DC experience include SDM can and should be recognized as an alternative to guardianship for transition age youth, including those with IDDD in special education. While it is helpful to have a legislative mandate, state law change is not required for implementation of SDM in schools. Existing Family Educational Rights and Privacy Act, FERPA, forms can be modified to document SDM arrangements and ensure parents and caregivers, in their capacity as supporters, receive access to the student's educational information and continue to be invited to IEP team meetings. SDM can and should be introduced early in the educational process, ideally beginning in pre-kindergarten. This is particularly true with respect to the development of general decision-making and self-advocacy skills, which are required for effective SDM later in life. Conversations and skill-building efforts relating to decision-making should therefore begin early, well before the student's 18th birthday, in order to maximize the chances that less restrictive alternatives to guardianship will be used. Educational agencies and schools must recognize the right of adult students in special education to knowingly and voluntarily execute powers of attorney under state law to designate an agent to exercise their IDEA rights. To do otherwise denies adult students with disabilities an important civil right simply because they receive special education services, which is discrimination based on disability in violation of Section 504 of the Rehabilitation Act and Title II of the Americans with Disabilities Act. Given the link between self-determination and community integration, states should include benchmarks related to SDM in their Olmstead plans. These official documents are ways states document their commitment to and plans for providing services to people with disabilities in the inclusive and integrative settings pursuant to the ADA. To minimize the chances that they are overused or misused, any non-judicial alternatives to guardianship that are triggered by some form of certification of a person's incapacity, such as the DC Healthcare Decisions Act or the DC educational representative process must A. First require the express ruling out of the availability of alternative voluntary options, such as durable powers of attorney for healthcare or educational powers of attorney, and B. Be easily, I'm assuming accessible. STM can and should be recognized as an alternative to guardianship for transition age youth, including those with IDDD in special education. While it is helpful to have a legislative mandate, state law change is not required for implementation of STM in schools. Existing Family Educational Rights and Privacy Act, FERPA, forms can be modified to document STM arrangements and ensure parents and caregivers in their capacity as supporters receive access to the student's educational information, and continue to be invited to IEP team meetings. Page 64. STM can and should be introduced early in the educational process, ideally beginning in pre-kindergarten. This is particularly true with respect to the development of general decision-making and self-advocacy skills, which are required for effective STM later in life. Conversations and skill-building efforts relating to decision-making should therefore begin early, well before the student's 18th birthday, in order to maximize the chances that less restrictive alternatives to guardianship will be used. Educational agencies and schools must recognize the right of adult students in special education to knowingly and voluntarily execute powers of attorney under state law that designate an agent to exercise their IDEA rights. To do otherwise denies adult students with disabilities an important civil right simply because they receive special education services, which is discrimination based on disability in violation of Section 504 of the Rehabilitation Act and Title II of the Americans with Disabilities Act. Given the link between self-determination and community integration, states should include benchmarks related to STM in their Olmstead plans. These official documents are ways states documents their commitment to and plans for providing services to people with disabilities in the inclusive and integrative settings persuasive to the ADA. To minimize the chance that they are overused or misused, any non-judicial alternatives to guardianship that are triggered by some form of certification of a person's incapacity, such as the DC Healthcare Decisions Act or the DC Educational Representative process, must A. First require the express ruling out of the availability of alternative voluntary options, such as durable powers of attorney for healthcare or educational powers of attorney, and B. Be easily challengeable by the person with the alleged disability. While state law, regulation, and policy changes to advance alternatives to guardianship are needed, more is required to ensure full implementation for people with IDDD on the ground. This includes intense and frequent education of people with IDDD, their families, state agencies, school personnel, judicial and court officers, attorneys, healthcare professionals, and financial institutions. When promising procedures and policies to promote alternatives to guardianship are introduced in schools, educational oversight agencies must develop tracking mechanisms so that they can trend the way in which IDEA decision-making rights are exercised by and or for adult students with disabilities, e.g. through SDM, powers of attorney, educational representatives, or guardianship, so that the impact of these reforms can be concretely assessed and monitored. Probate court resource centers that provide PROS assistance to people seeking guardianship should also proactively provide information about less restrictive alternatives that are also available under state law, such as SDM, powers of attorney, representative payees, and substitute or surrogate healthcare decision makers. State law should not only ensure that there is an unconditional right to counsel for people in initial and post-appointment guardianship proceedings, but also that counsel is expressly required to zealously advocate for their clients' expressed wishes. DC's law promoting limited guardianship is not significantly impacting the scope of an appointed guardian's authority over people with IDDD, which has tended to be general or plenary in nature. Based on recent data, judicial education to ensure limited guardianships are a viable option for people with IDDD is needed. Although it is too early to meaningfully assess its impact in DC, instituting periodic court reviews of whether a guardianship continues to be the least restrictive option for a person is a promising DC reform. DC courts should ensure this review process remains fully funded and should continue to move towards expanding it to more people whose guardian was appointed before 2015. Establishing such review processes should be considered in other states. Page 65. The DC Superior Court Probate Branch offers regular orientations to family members on what the legal responsibilities of guardians are. It and other state courts should also train family member and professional guardians on using SDM within a court-appointed guardianship to increase self-determination, as well as train people who have guardians about ways they can access the new complaint process and initiate restoration of rights proceedings. As one community advocate in DC said, DC is at the forefront of a lot of important legal reforms designed to promote recognition of the decision-making rights of people with IDDD. Yet, I still regularly get calls from parents and other family members who say they were told to get guardianship and are not aware of the many less restrictive options that are available in DC. For these promising reforms to have an impact, a culture shift still needs to happen. At the family level, at the school level, at the judicial level, at the governmental agency level, that recognizes guardianship is not the only game in town for DC residents with IDDD.